have a seat. Good morning. My name is Kyle Rogers. I'm a referee assigned by the Oklahoma Supreme Court to hold this statutorily required hearing in the matter of the application of the Oklahoma Turnpike Authority for approval of not to exceed $500 million Oklahoma Turnpike System Second Senior Lien Revenue Bonds, Series 2022. According to Title 69 of the Oklahoma Statute, Section 1718, the Oklahoma Turnpike Authority and their counsel will present their case for approval of these bonds, and then anyone that would like to register a protest will be recognized by the court. We will begin with the attorneys and protesters who filed written objections, and then some people have signed up, and then after that, if you would like to be recognized, the court will recognize you to speak. And then the Oklahoma Transit Authority will be given the final word in a brief rebuttal. The court will then, after this hearing is completed, receive all these materials and consider a recommendation from the referee's office and will proceed accordingly. So, Mr. Davidson, if you would like to begin.
Good morning, and may it please the court. My name is Jared Davidson, and I represent the applicant petitioner in this matter, the Oklahoma Turnpike Authority. As authorized by Title 69, Section 1718, the petitioner respectfully requests this court accept original jurisdiction, deny any challenges or protests to the issuance of the petitioner's proposed turnpike revenue bonds, and validate the issuance of not to exceed $500 million of Oklahoma Turnpike System Second Senior Lien Revenue Bonds, Series 2022. Validation of the authority's bonds by this court is proper for three primary reasons. First, notice of these proceedings has been given in compliance with the requirements of Title 69, Section 1718. Second, the bonds to be issued will fund statutorily enumerated projects and refund certain outstanding indebtedness of the authority as authorized by Section 1705 and 1719 of the Enabling Act. And third, that the authority has complied with all technical requirements for the issuance of turnpike bonds pursuant to Section 1709. The Oklahoma Turnpike Authority was created in 1947 for the sole purpose of providing an instrumentality of the state to construct, operate, maintain, and repair turnpike projects in Oklahoma, which have been deemed to be the public highways of the state. Under the Enabling Act, the authority is granted the power to issue turnpike revenue bonds to fund the construction and maintenance of turnpike projects. Specifically, the authority is authorized to provide for the issuance of turnpike bonds for the purpose of paying all or any part of the cost of one or more projects. In practical terms, this means the authority can fund one project, multiple projects, or combined refunding of existing turnpike projects with new construction projects into one issuance of turnpike bonds. The authority's power to issue bonds to fund turnpike projects is well settled, and this court has validated prior issuances of bonds of the authority on at least 12 prior occasions, having never rejected a bond issuance. What started as a single project to connect the Oklahoma City and Tulsa metropolitan areas now spans over 630 miles of safe, modern roadways to efficiently move Oklahomans and interstate travelers across our state. However, the infrastructure, traffic, and safety needs of Oklahomans continue to evolve as new technologies are invented, population growth continues, and the major metropolitan areas continue to expand. In December 2021, the authority announced the development of a $5 billion, 15-year long-range capital plan to govern the future of turnpike expansion and improvements. And in February 2022, announced the Advancing and Connecting Communities and Economies Safely Statewide, or Access Oklahoma initiative. At its core, Access Oklahoma is about improving safety for travelers passing through Oklahoma on 11 different turnpike facilities. Access Oklahoma provides for reinvestment in turnpike infrastructure statewide and affords important relief along the I-44 and I-35 corridors, which continue to see growing traffic volumes and increases in traffic safety-related issues. Access Oklahoma provides for the completion of the Oklahoma City Outer Loop, authorized in 1987, through the construction of the Tri-City Connector and the East-West Connector, as well as the easternmost segment of the authorization, which extends from Mustang to the vicinity of Norman, the so-called South Extension, authorized in 1993. Pursuant to Section 1718, the authority may file an application with the court and seek a judicial determination on the validity of a proposed issuance of bonds. The power of the court to hear this matter is vested in Article 7, Section 4 of the Oklahoma Constitution, which provides that the court may exercise such other and further jurisdiction as may be conferred by statute. The authority does not take for granted the invocation of the court's power to render an opinion on the validity of the authority's bonds. However, due to multiple legal challenges involving the funding and construction of the proposed access projects, the authority has filed its application with the court to provide notice to the citizens of the state of its intent to issue its Series 2022 bonds to accomplish the initial funding phases of the Access Oklahoma projects, as well as refund certain outstanding bonds of the authority. This court is vested with the exclusive original jurisdiction to not only validate an issuance of bonds pursuant to the Enabling Act, but also, as stated in OTA versus District Court of Lincoln County in 1950, extends to passing upon the validity and constitutionality of the bond issuance and the sufficiency of the legislative authority to construct and operate those proposed turnpikes. This extraordinary action is being taken to not only allow this particular issuance to move forward, but to also prevent additional legal proceedings from being filed in the district courts across the state in an attempt to keep the authority from exercising its statutory mandate to facilitate vehicular traffic, which has been deemed to be an essential governmental function. The petitioner has caused a notice of hearing on these proceedings to be published in the Tulsa World and the Oklahoman, both newspapers of statewide circulation. That notice provided that interested parties may file protests and be present at this hearing to challenge the proposed issuance. A copy has been filed with the court. The legislature has provided very broad powers to the authority to fulfill its mission of facilitating vehicular traffic and issuing bonds to construct turnpike projects. In fact, the only limitation on the authority's powers is that a particular project must be legislatively authorized. Section 1705 of the Enabling Act identifies 35 individual projects of which all or a part are authorized to be constructed by the authority. And I quote, at such locations and on such routes as it, meaning the authority, shall determine to be feasible and economically sound. The descriptions of the projects vary, but that is by design, as the legislature has vested the exclusive power to the authority to determine in its sole discretion which projects to determine to be feasible, design, and construct in accordance with statutory authorization. This includes the entirety of a route, potential interchanges, and the discretion to start and end a turnpike in the vicinity of a particular authorized location. In fact, this court said in Owens versus OTA in 1954 that once the authority has selected and designated a route, the courts will not inquire into the matter for the purpose of demanding why some other route was not chosen. Quite simply, the legislature has determined it to be in the best interest of the state to let the transportation officials at the authority exercise their discretion and provide the necessary expertise to best serve the citizens of the state of Oklahoma. The Turnpike Authority is the sole entity authorized and directed by statute to design, construct, and operate turnpike projects to help relieve the stresses on the tax-supported state highway system. There's no question that each of the access projects has been authorized by legislative enactment. In fact, many of the components of the access program relate to maintenance and upgrades to previously constructed turnpikes, which date back to the adoption of the original Enabling Act in 1947. They consist of important safety upgrades to relieve congestion and provide safe modern roadways to accommodate that efficient vehicular movement, namely to the Turner, H.E. Bailey, Will Rogers, Indian Nations, Muskogee, John Kilpatrick, Creek, Cimarron, and Gilcrease turnpikes. Each of these turnpikes have been the subject of multiple bond issuances since 1950, and with the exception of the H.E. Bailey Spur and the South Extension project identified in subparagraph 28, have previously been validated through prior proceedings before this court. Each of the Access Oklahoma projects represent a continuation of the authority's purpose and mission to facilitate that vehicular traffic and remove the present handicaps and hazard on the congested roadways of the state. The Series 2022 bonds represent initial funds to provide for continuation of that mission over the next 15 years and will be used to start projects, acquire right-of-way, and finalize plans and designs for those turnpike facilities. It appears the proposed new construction alignments that are part of the Access Oklahoma projects are the most controversial relative to this package, but they've been in statute for 29 and 35 years, respectively. The proposed components of the Oklahoma City Outer Loop and South Extension will help facilitate vehicular traffic by developing reliever routes to provide an efficient alternative to the congested I-35 and I-44 corridors, which can no longer be economically expanded or afforded by the state tax-supported transportation network, and are essential to managing the continued growth of traffic in the Oklahoma City metropolitan area. To put this into context, a recent traffic study conducted by EST in 2020 and provided to the court shows that traffic increases exponentially each mile as you approach the I-40 junction in downtown Oklahoma City from Norman, peaking at over 174,000 vehicles per day with an average of 5 serious accidents, not counting the numerous fender benders that occur along that stretch every single day. Using conservative growth projections of approximately 3%, that number is expected to double to nearly 340,000 vehicles traversing that stretch of interstate in the same corridor by 2050. The Tri-City Connector and the East-West Connector are the last remaining segments to complete the Oklahoma City Outer Loop, which was authorized over 35 years ago and codified at 1705 E20. The Oklahoma City Outer Loop was added to the authorized projects list in 1987. The Enabling Act was also amended to provide that the authorizations added be financed as one issue under one bond indenture. The authority then initiated a plan to construct the projects in phases as authorized by the Enabling Act, while taking advantage of the opportunity to transform its bond issuance process. In 1989, the authority sought and obtained validation of its bonds to construct the 1987 projects and refund prior bonds. The 1989 bonds are important because this was the first opportunity the authority had to consolidate all previously constructed projects under one master trust agreement or bond indenture to operate as the existing Turnpike system, which it continues to operate under today. The precedent from the pleadings in the 89 validation and the opinion itself explicitly state that the authority was constructing the first phases of the enumerated projects. Paragraph 4 of the 89 validation proceedings lists the projects as the Oklahoma City Outer Loop Expressway, Section 1, the Tulsa South Bypass, Section 1. The third turnpike to be built under this section is Section 1 of a State Highway 33 turnpike in Mayes and Delaware counties. And lastly, Section 1 of an I-35 to I-40 turnpike in Murray and Pontotoc counties. The statutory directive was fulfilled as at least part of each of these authorizations were accomplished through the issuance of the 89 bonds. Neither this court nor the Enabling Act required the construction of the totality of a turnpike project, and nor should it impose one here. But rather, the Act states that the authority is given the discretion to build all or any part of one or more projects through the issuance of bonds as it determines to be feasible. The 89 bonds were challenged on many grounds, including excessive delegation of authority and potential Open Meeting Act violations. But the court found the bonds had been authorized in accordance with the Enabling Act. Since the validation of the 89 bonds, the authority has constructed multiple phases of the Oklahoma City Outer Loop, as specifically authorized and contemplated, where it may finance and construct all or part of one or more turnpike projects. However, even after multiple phases of development, the Oklahoma City Outer Loop remained contentious. The Kilpatrick Southwest Extension and Kickapoo components of the Oklahoma City Outer Loop were challenged in 2016, asserting constitutional violations of log rolling and the rule against perpetuities. The court rejected those arguments and validated the bonds, and the projects were completed as part of the authority's driving forward plan. Today, the protesters now seek to argue the opposite of those in the 1989 and 2016 cases, that if combining the projects did not run afoul of the Constitution, that now not enough of the projects were completed in 1989. An absurd interpretation that would lead to absurd results in the discretion of the construction of turnpikes for the authority. The Tri-City Connector and East-West Connector are the final two components of the currently authorized Oklahoma City Outer Loop. The project descriptions have not changed since 1987, and due to continued growth in the South Oklahoma City metro area, has made the completion of these projects a high priority for all state transportation officials. The third new construction project, identified as the South Extension by the Authority, due to its connection to the East-West Connector and the newly constructed Kickapoo Turnpike, represents the easternmost portion of the statutory authorization found in 1705 E28 that is described as follows. A new turnpike and bridge, or any parts thereof, from a point in the vicinity of Mustang, southerly across the South Canadian River to the H.E. Bailey Turnpike in the vicinity of the city of Tuttle, and then easterly across the South Canadian River to a point in the vicinity of Norman. This project was authorized in 1993, and the first phase of this authorization, called the Norman Spur, was completed in 2001. There seems to be a bit of confusion surrounding the authorizations in both subsection 20 and subsection 28. These two projects are distinctly separate authorizations, and the legislature could have only meant for them to be separate alignments, as they were codified 6 years apart from each other. Important in this language are the two distinct river crossings, one moving south from Mustang across the South Canadian River, and again easterly across the South Canadian River for a second time to a point in the vicinity of Norman. Nowhere does the statute specify exactly where the river crossings are to occur or the exact location of the beginning and ending of the turnpike facility. We actually agree that the statutorily enacted projects must be interpreted in accordance with their plain and ordinary meaning, and the authority believes it is giving full credence to the Enabling Act. The protesters ignored the language of the Enabling Act that provides that once a project is statutorily authorized, the construction of projects are within the sole discretion of the authority and may be constructed at such locations and on such routes as it shall determine to be feasible and economically sound. And once a project location is authorized, it may begin and end in the vicinity of an authorized location. In fact, the authorization for subparagraph 28 says to a point in the vicinity of Norman. It does not specify east, west, north, or south. The route designed between these 2 points is solely designed and determined by the authority. Protesters attempt to inject their reading of the statute for the placement of the Turnpike project, but the legislature has delegated that determination solely to the authority through the Enabling Act. Likewise, even if there was deemed to be some ambiguity, the rules of statutory construction provide that when discerning legislative intent, it will be ascertained from the whole act in light of its general purpose and objective, considering relevant provisions together to give full force and effect to each, as provided in Keating versus Edmondson in 2001. And the court will not limit consideration to one word or phrase, but will consider the various provisions of the relevant legislative scheme to ascertain and give effect to the legislative intent and the public policy underlying that intent, as stated in YDF versus Schlumar in 2006. Importantly, while the protesters would have you believe legislative intent can never be discerned by the subject matter of unenacted legislation, as provided in Allen versus State in 1988. It is clear that the legislature has provided great discretion and maximum flexibility to the authority in its Enabling Act to achieve the goals of facilitating traffic and providing relief from the congested roadways of the state. Further, it also appears that the very first validation proceeding in 1950 answers this question, which dealt with the discretion to design the routes and locate the termini of the now Turner Turnpike. The original statutory authorization for the Turner provides for, and I quote, construction of a toll road between Oklahoma City and Tulsa. That's it. That's all of the description in the Enabling Act. In fact, the originally constructed turnpike started and ended about 10 miles from the center of each city. The court provided in paragraph 65 that it would seem to be impracticable to locate the termini of a much-traveled road so as to empty travel thereon into a business district or into a thickly populated residential area, and that it is within the discretion of the authority to so construct toll roads, and that the selection of a termini does not represent the slightest abuse of discretion. Likewise, with the exception of the authorizations in subsection 20 and 21, which provide for the defined Oklahoma City Outer Loop and the South Tulsa Bypass, the other 33 listed projects are generally broad descriptions, wherein the legislature has vested the authority with the sole power to design and determine the routes best suited for the statutory authorization, while also providing it the flexibility to take into consideration growth, traffic patterns, and safety issues which may not otherwise be addressed due to funding challenges with the state tax-supported highway system. Some have also raised issues that because the proposed middle section of the statutory authorization is not currently being considered in this group of projects, that somehow invalidates or obfuscates the authority to build the easternmost segment. The authority has a long history of splitting up projects into phases as they become feasible. And the Enabling Act specifically allows for this to happen, with the legislature delegating to the authority which routes to design, build, and construct in whatever phases or fashion as the authority deems to be feasible. Again, the 89 validation proceedings are instructive in this matter, as the Oklahoma City Loop and the South Tulsa Bypass were all completed in multiple phases. And additionally, the Chickasaw Turnpike authorization, which extends from Duncan to Davis to Ada, and then on up to Henrietta, and yet only a small 17 portion of that turnpike from Sulphur to Ada has been completed. And further, the Cherokee Turnpike, which provides authorization from US 69 to the Arkansas border, has only been constructed from just beyond the Neosho River to approximately 11 miles west of the Arkansas state line. Though there is not one comprehensive map of the various projects from 1993, the feasibility studies, the earliest maps, show that multiple locations for the termini of this particular project, from Highway 9 up to a point with the proposed southeast portion of the Oklahoma City Outer Loop. The authority has chosen to locate the termini of this turnpike facility to connect with the east-west connector, which is still within the vicinity of Norman. Actually, it's right on the border of the city limits, which makes the most sense to relieve congestion and improve safety to provide a complete bypass around the congested I-35 corridor. If a point 10 miles from the city limits has previously been ruled to be in the vicinity of an authorized project, as was the case in the Turner case from 1950, then ending in the city limits certainly has to be fine as well. As it's specifically authorized by the Enabling Act, the authority is advancing this project in phases, exactly in the same fashion as the Outer Loop and the other projects the authority has constructed. The first two phases constituted the South Canadian River Bridge crossing south of Mustang, and then completion of the Norman Spur from the H.E. Bailey to State Highway 62. Since the initial completion of that project in 2001, the state received significant funds from the federal government to complete the transformation of Highway 9 from US 62 to I-35 to become a dedicated 4-lane divided highway. However, as population growth continues in the area, the authority is reserving the right to continue to study the need for a tolled highway facility to connect from State Highway 62 to I-35, logically to the same termini along I-35 as the proposed south extension, to provide the maximum amount of traffic congestion relief and multiple avenues for travelers, whether they be heading north, south, east, or west. This hits at the fundamental core of the Enabling Act, which provides that the authority is charged to facilitate vehicular traffic throughout the state, remove the present handicaps and hazards on the congested highways, and provide for the construction of modern highways embodying reasonable safety devices. Moreover, the authority is vested with the sole discretion and power to determine those routes and the feasibility of their construction. The authority does not operate in a vacuum, but rather provides the necessary resources and facilities the Department of Transportation simply cannot provide to relieve traffic congestion. The authority is also seeking to refund the outstanding amount of its previously issued bonds or notes. Section 1719 of the Enabling Act provides that the authority may issue refunding bonds. However, due to the various district court proceedings challenging the authority's proposed issuance As a condition precedent to the issuance of the bonds imposed by the Council of Bond Oversight, the authority is currently restricted from issuing its refunding bonds until all challenges have been resolved or validation of the authority's bonds by this court is received. The proposed Series 2022 bonds do not deviate from the procedures and protocols established by the Enabling Act and previously validated by the court. The authority has simply chosen to combine the refunding and new money projects into one issuance to reduce transaction costs and continue the efficient operation and management of the Turnpike system. The refunding is very straightforward and is being undertaken for interest cost savings. The authority has complied with all technical requirements for the issuance of its bonds as well. Section 1709 of the Enabling Act imposes certain limitations on the authority's bonds with respect to establishing maximum interest rates, discount rates, and maturity dates. The authority's form of bond resolution and all draft major documents for the bonds have been provided to the court, which is standard practice and no different than the procedure followed for over 70 years. We obviously can't execute those bonds until they're actually sold. In particular, the preliminary official statement and the traffic and revenue study located therein, which are investor documents, cannot be completed until validation of bonds by the court. The bond resolution contemplates the refunding and access projects, as well as establishes certain parameters or guidelines for the issuance of the bonds. Their not to exceed amount is a little bit higher than what we're asking for with respect to $1 billion versus the $500 million in our application. There's a not to exceed interest rate of 6% and a discount rate of not to exceed more than 3% and a maximum term to maturity of 32 years, all below the maximum requirements as allowed in state law. The authority's bonds are self-liquidating revenue bonds and are limited special obligations secured by toll revenues and are not backed by the full faith and credit of the state. All bonds issued by the authority are issued under a common trust agreement, which has been in existence since 1989, as authorized by Section 1710 of the Enabling Act. The Master Trust Agreement governs the issuance of bonds, including senior lien, junior lien, and interim notes of the authority. And the revenues from the Turnpike system are pledged through the repayment of all of the authority's bonds pursuant to the Master Trust Agreement and would be available for debt service on the proposed bonds. The authority is expressly authorized to facilitate vehicular traffic across the state by constructing, maintaining, operating, and repairing turnpike projects and issuing bonds to accomplish that purpose. The authority is given the discretion to determine the feasibility and route alignments pertaining to the construction of all or any part of one or more projects. The turnpikes are public highways, and the authority is fulfilling its essential governmental function of relieving the congested roadways of the state and providing safe, modern facilities to facilitate the efficient flow of traffic. The Authority Series 2022 bonds follow well-established guidelines and principles, as enumerated by the Oklahoma legislature and this court for the issuance of bonds. Notice of these proceedings has been properly given. The projects and the refunding are authorized by the Enabling Act, and all technical requirements for the issuance of bonds have been met. For these reasons, the authority respectfully requests the court accept jurisdiction, deny any protests or challenges to the issuance of the bonds, and validate an issuance in the amount of not to exceed $500 million of Oklahoma Turnpike System second senior lien revenue bonds, leaving the bonds so approved and the revenues pledged to their payment incontestable in any court in the state. Thank you.
I have a question or two if you
bet.
can indulge. I want to ask you about the court's grant of jurisdiction from the legislature. If, for instance, the court concludes that the south extension is not statutory authorized, can it carve that out of the bond approval?
Yeah, we certainly believe that it is authorized, obviously. But should the court find that the authorization does not exist, then we believe the general severability rules would apply. So if the south extension is deemed to not fit this authorization, we would ask the court to strike that specifically from the opinion and allow the issuance to proceed relative to the other turnpike facilities.
And let me ask you about the conditional approval from the Council on Bond Oversight. The statute seems pretty straightforward in that the council has to approve or disapprove of the bonds. Does it have the inherent authority to conditionally approve those bonds like it did in this case?
I believe so. The Council Bond Oversight has a history of providing conditional approval, relative to other state bond issuances. You'll notice there are actually two different applications that are provided to the Council Bond Oversight, one for conditional approval and one for final approval. That's generally spaced out just due to the relative timing of how a bond issue actually gets executed, as it's going, throughout the state. So for a great example would be the Oklahoma Development Finance Authority's Master Lease Program, where every year they RFP for service providers. They bring a blanket authorization for up to $200 million and $50 million respectively for their master lease programs. However, each individual issue that's undertaken by the authority in that instance must come back before the Council of Bond Oversight for final approval.
So the court's approval of these bonds would not bar the compliance with those conditions in what the Council on Bond Oversight provided. Is that right?
Yeah, we actually agree with that as well. So we think that at least the initial case filed in Cleveland County relative to the PIKE case, all of those relevant answers and questions would be provided by this particular case. With respect to the Open Meeting Act violation case, which you're probably aware, there's been a writ filed before the court for that. But we think that that is a wholly separate issue, and that any particular attempt at jurisdiction relative to the construction of projects is unfounded in that particular case. And therefore, again, that Open Meeting Act violation, if that case continues and were to continue through its full completion, would actually have no impact on the ability of the Turnpike to actually achieve its goals of accomplishing these projects.
Okay, that's all the questions I have. Thank you, Mr. Davidson. The first protest that the court will recognize, the Cleveland County litigants. If you're ready, Mr. LeBarrett.
Mr. Rogers, thank you very much. I'm Richard LeBarth, and I am co-counsel with Stan Ward and Alexei Tarasov in the Cleveland County court case styled Hirschfield versus Oklahoma Turnpike Authority, in which we represent some 245 different individual plaintiffs. As you know, we did in fact file a protest in this cause, but in no way do we wish to or concede that we thereby became parties to this action. As I think you're well aware, Mr. Rogers, the Turnpike Authority has recently filed an application or a motion seeking to have the Supreme Court assume original jurisdiction over our case. And my understanding of the law in this instance, they also are seeking a writ of mandamus or prohibition or both. We have, as I understand it, 30 days. It could be 20, I'll have to confirm that. But in any case, we just received it, so I'm not prepared to talk about the merits or demerits of that particular filing this morning. But I do wish to say a couple of things, if you'll allow. Number one, I think everyone in this room is aware, or ought to be aware, that the Council on Bond Oversight has clearly conditioned their approval or their recommendation on this $500 million bond issue on the resolution of not only our case, but also the other case, which is typically or commonly referred to as the PIKE case. And they expressly specified that these two cases must be dealt with and resolved, I think their words were, favorably to the OTA. With respect to, and I won't attempt to speak to the PIKE case, but as to our case, I will simply say that we were a little slow getting started because the judges in Cleveland County had recused, but ultimately the case was assigned out by Judge Morris, who's the presiding judge for that district, to Judge Olson, who's district judge in Seminole County. And Judge Olson has moved with great speed and has established what I would call a rocket docket. So of course, we would say that the district court is infinitely better equipped, and I mean no disrespect to you, Mr. Rogers, but the district court routinely deals with any number of discovery disputes and so forth. And since we do have an extremely fast-track scheduling order in that case, it would be our position that that really is the sensible way to proceed, that he has in fact set us for trial in early December. So it doesn't really get a whole lot faster than that. Also, our case is a limited issue, single issue case. Now, I know that counsel just alluded to the old case, the old bond application case, in which the court addressed, I would say in passing, a question about Open Meetings Act. We believe that that particular case, in that respect, is no more than dictum. But in any event, we're going to keep our powder dry, and we'll address that in due course in our proper response. Just from a common sense standpoint, if the idea is that we need to get to a resolution one way or another as rapidly as is consistent with due process, then the proper thing to do would be to allow Judge Olson to proceed with our case, the single issue case. And in fact, discovery in that case is due from the OTA this Friday, and we have served notices for depositions beginning next Monday. So it's our intention to move with all deliberate speed in our case. That's all I have, Your Honor. And again, I would emphasize that my appearance here today does in no way hopefully signify that we are submitting or consenting to the jurisdiction of the court as a matter of original jurisdiction.
The court will note that. Thank you.
Thank you, Mr. Rogers.
The PIKE OTA case, Mr. Norman.
It's going to take me just a minute here. Have some demonstrative aids. Here we go. Mr. Moore. There you go. If we can dim the lights just a little bit, Mr. Carter, on this presentation. This is a case where just sitting and talking doesn't do the case justice. We need to get out maps and see what they mean. This is part engineering, part law, part English teacher, part politics. And we really have to envelop all of them in here. I'd like to start not by just going over the history of the OTA or the history of PIKE off OTA, but get right down to brass tacks and show really what three turnpikes are in controversy here. Here's the east-west connector. Now, the OTA has kind of shifted back and forth in how they define these turnpikes. We think strategically. The east-west connector, and this is their material. These are their resolutions from June 9th, their route resolutions from June 9th. The east-west connector is in purple there. You can see the southwest connector, the southwest extension as currently defined going down beside Lake Thunderbird. The east-west connector goes from a little north of the H.E. Bailey Turnpike, that's not the H.E. Bailey Turnpike right there actually, to I-35 on a stick along the Indian Hills Road, border of Moore and Norman Path, out to about where you see Lake Thunderbird, which is between 72nd and 84th, and then it does a loop up to I-40 and the Kickapoo, where the east-west connector, as they currently define it, ends. They used to define that ending as part of the south extension, but they got themselves into trouble, which we'll talk about later with that. It ends up there with the Kickapoo at I-40. Now, what they have done is they have placed this squarely under 1705 E20. And if it weren't for 1705 F, they could have done this back in 87, 88, 89. In fact, they had to do it because of F. They had to do it back in 87, 88, 89, or not at all. So in other words, the route was authorized subject to the restrictions in Section F, which are an impenetrable wall of legislation against them building the East Connector now, 33 years later. Here's the South Extension as they currently define it. This doesn't go, I wrote down the, and I agree. Section 28 is where they place this. And Section 28 allows them to hook up to the H.E. Bailey in the vicinity of Tuttle, which they sort of did with the H.E. Bailey Norman Spur. They played a little fast and loose there, I think. But they hooked up with the H.E. Bailey to spin their A new Turnpike singular authorization with 20, came across to hook up easterly with Highway 9. And note, down at the bottom, that's Purcell. That's in the city limits of Purcell. There's nothing in 28 that says anything about Purcell in the vicinity of Purcell. It says you hook up at the H.E. Bailey Turnpike in the vicinity of Tuttle, which is way north of there. And then you move easterly. You don't get to dip down south. You don't get to dip back up north. Then you move easterly to a point in the vicinity of Norman. What they've done here is they've dipped all the way. They've started in Purcell, which the statute doesn't authorize, and they've moved up northerly, due north, which the statute doesn't authorize, to connect all the way up with the east-west connector. And their old version had it continuing on. They call it the South Extension because their original version hooked up with the Kickapoo. But there's nothing that says they can go north and hook up with I-40 either. Here's the Tri-City Connector, which kind of falls in the same problem as the east-west connector. It's predominantly a Cleveland County Turnpike. That big gray part you see is the airport. So it kind of goes down from Airport Road to I-44 around between 104th and 119th in Oklahoma City. And it suffers from the same problem that the east-west connector does. In other words, it could have fallen within the E20 Oklahoma City outer loop, but for the restrictions now on doing subsequent and multiple bond issues to just do one of 4 turnpikes. So the Tri-City Connector is not authorized either. Here's the 2 statutory authorizations at issue. 20 allows them to get a turnpike east and north from the Moore-Norman area to I-40 at Tinkerfield. That's their last little kicker of the east-west connector. 28 ends easterly across the South Canadian, H.E. Bailey Turnpike in the vicinity of the city of Tuttle, and then easterly, and only easterly, across the South Canadian River to a point, as the city of Norman does an excellent job of constructing that there, to a point in the vicinity of Norman. Now here's 1705F, and this is where the Oklahoma Turnpike Authority could not be more wrong. Usually I would agree if they're up doing a Turner, if they're up doing an H.E. Bailey, if they're up doing an old turnpike, they have considerable discretion with broad authorizations and no bundling restrictions. But here the key language is, and we've bold-faced in white and we've bold-faced in yellow, any bonds issued for the construction of the proposed turnpike referred to in subparagraphs 10, 20, which is the Oklahoma City Outer Loop, 21 and 22 of paragraph E of this section, shall be issued as one issue, one bond issue, not 3, not 4, not 5, not 10, not 20, not bond issues issued 33 years apart for all 4 of the proposed turnpikes. In other words, what that tells us is they can't build the outer loop by itself in phases, and they can't build the outer loop as part of their usual discretion to do part of all or one or more turnpikes. The OTA specifically said, well, this authorizes them to build in phases all or part of one or more projects. That's just wrong. That's like trying to say the sun revolves around the earth. That's just absolutely wrong. F takes that away from them. And the legislature was specifically very specifically in this 1987 Turnpike package mandating that it was an all or nothing proposition. It was a one-shot deal. You have to put them all four together. There are two things the OTA is doing wrong here. One, they're trying to do multiple bond issues after doing their original issue. This is one bond issue. They're going to keep issuing bonds. This is a $5 billion project. This is only $500,000 issue. They're going to keep doing bond issue, bond issue, bond issue, bond issue, violating that statute in a serial manner. They're violating it with this first one. And the second problem, and these are intertwined, this is not an either or. This is a dual violation. They're just trying to do a piece of the Oklahoma City outer loop. They're not including 10, 21, or 22. And they can't because they had one bond issue to do that. Now, I would agree they could do all or part of that in that original package, but it was all or part. And here's where the evidence kind of comes in to assist this. You read this and you say, this is what the statute means, but am I missing something? After all, they did the kickapoo. The wrong argument was made in the kickapoo. But let's look back at what the OTA thought and what the legislators thought and the governor thought about this when it happened. Here's some of the articles in our appendix. Look at this, very first sentence. The Oklahoma Turnpike Authority Thursday urged the legislature to repeal a 1987 law that requires 4 proposed toll roads to be built as a package or not at all. That's right. That's the right construction of the statute. Now, the problem they're having here that's being reported is they've gotten into a situation where they've bitten off more than they can chew. They can't get it all done. The legislature has bound them to say, you got to do all or part of these 4 turnpikes together in one bond issue. And you go through our articles and you see they're going to Wall Street, they're going to the underwriters, and the underwriters in Wall Street are saying, this is too much. You can't do all this. So they're having to scale it back or split it up. And they never got the authorization to split it up. They did comply with the statute in 1989 because they built part of all 4 turnpikes, but that was their one shot. That was it. That's the plain language of the statute, and that's exactly how the OTA understood it back at the time. I would submit to you that this legislative memory has been lost over 33 years, and that's exactly our problem here. Here we go again. Another Daily Oklahoman article. The 1987 legislature approved building of 4 toll roads, including the Oklahoma City Turnpike, but only if part or all, there we go. I would agree with the Turnpike Authority there. They don't have to build the whole thing, but they have to build part or all 4 of them at the same time. Right there is legislative intent expressed at the time. Now there it is. Here's another article where Bellman and the OTA are realizing they're kind of in a pickle, they're in a bind. It's come back as too expensive to build the whole thing, and they're having to scale it back and slow it down. Here's another article where, as they got into it, there was a big fuss over this little stick from Sulphur to Ada. All they could do was a 2-lane turnpike. Those of us who were back then remember that, and that was a big political fuss. They were stuck with it. That's all they could get done. And the people in the area were mad. They were talking about, well, can we get this split up? And Bellman says again, he said a statutory requirement that the turnpike in southern Oklahoma be built is blocking consideration of other turnpikes. It's the legislature that has tied all 4 of these facilities together and made it an all or nothing proposition. That's exactly what it was. Bellman, like Governor Stitt now, like any governor between the two, is on the Turnpike Authority. He's really the top dog in charge of it. So this, again, is Bellman, the governor who signed the bill, Bellman, the member of the Oklahoma Turnpike Authority, telling us what this means. It's a one-shot deal. It's all or nothing. Our problem is we can't build your turnpike from Henrietta to Okmulgee because Wall Street and the underwriters won't let us. This is all we can build. Here they are trying, the OTA is trying to split this up again and get the get the authorization to build chunks and not all four together. They put it in a economic development bill at the end of the '88 legislative session to split them up. And you can see here where they're talking about having to reduce their bond issue from $891.5 million to the $395.4 that is actually presented to the court in 1989. You can literally go through that opinion and find out how that breaks down, and go through the history in our appendix and find out how that breaks down. By the way, they got themselves ready in 1989. They got themselves ready in 1950. They got themselves ready in 2016. They haven't done that here. They specified to the court they were ready to go. They did all this feasibility and all this due diligence back then. They haven't done it here. Now, so they try to get these split up again at the end of the legislative session, and it doesn't work. So what this all shows us is it shows the OTA understands back then, when the bill is fresh in their mind and it's been first enacted, that this is a single shot deal. You have to both do just one bond issue, and you have to put all four turnpikes in. It's not a phases deal. It's not a you can do one or the other, you can make a choice. The legislature said, no, you're not going to prefer the Oklahoma City outer loop to these other three turnpikes. But that's what they're trying to do now. They're trying to go and basically violate what the legislature enacted in 1988 because they've gotten away with it, because no one's brought it to the court's attention. And they're trying to do exactly what the legislature did not want them to do back then, which was complete the Oklahoma City outer loop without completing the other turnpikes or doing the other turnpikes. Now, here's something that comes from the OTA. Again, it's in their appendix. And I think it's kind of their attempt to say what 28 would authorize. And we filed a motion where we talked about how they haven't included the whole studies and they haven't given us all the studies, and they need to do that. If you have the whole study, you find out they're not studying 28 here, they're studying 20. Do they have all these routes in 20? And here's the spur. They get to where they want to build a route here that hooks up with Highway 9 in Norman. And that's what they did. ODOT widened Highway 9. ODOT actually ended up doing this. And what OTA did was the spur, which this is substantially the spur route here, what they ended up doing. They're studying it in 1993, and if you get the whole study out, they're saying, well, is this 20? Look, here's the east-west connector, dotted out as an alternate route under 20. Here's the Tri-City connector, listed as a route under 20. I would submit to you that, yes, 28, once it's enacted, gives them this, and gives them this. Here's them coming across the Canadian River to Norman, and they could hook up with Highway 9. But they can't do this, because it doesn't tell them they can go back north. The legislature is not directionally challenged, as the OTA would have the court and the referee believe. The legislature knows how to tell someone, how to tell the OTA when they can go east and south, when they can go north and east, when they can go southeasterly, when they can go northeasterly, when they can go northerly, when they can go north. They didn't do it here. They told them, you hook up with the H.E. Bailey Turnpike and you go easterly to a point in Norman. That authorization doesn't say, you get to hook up with the H.E. Bailey Turnpike and stop, and then you get to phantom start again in Purcell, and then you get to run north all the way through Norman. That's just not what the statute says. They don't have discretion here. Discretion, as they alluded to, discretion depends first upon legislative authorization. When they talk about discretion, they're relying on cases that just tell them, put a turnpike between Tulsa and Oklahoma City. Of course that gives them broad discretion to put a turnpike between Tulsa and Oklahoma City. 20 and 28, modern times, the legislature restricts them much more than they did back in 1950 with the Turner. The legislature says, thou shalt at the end of this turnpike, which is a southwest Oklahoma City turnpike, not a southeast Norman and Purcell turnpike, thou shalt move from the H.E. Bailey Turnpike easterly to the vicinity of Norman. Now, here's another picture that has basically Access Oklahoma teed up along with some existing turnpikes. Here's some of the maintenance projects. Here's the outer loop. This is the Kilpatrick. This is the spur. This is the Tri-City connector. This is the spur. This is the south extension. They are not moving easterly to a point in the vicinity of Norman. They're starting in Purcell, different county, different township, and they're moving due north to try to hook up with the east-west connector and ultimately finish their outer loop. Now, why can't they do this? 2 reasons. 28 doesn't give it to them. 20 doesn't give it to them because of 1705F. To understand why 20 doesn't give it to them, you have to read the whole book. What they're trying to do is they're just trying to give the court, tell the court to stop at the middle of the book. You have to read the end of the book. You can skip over some of the middle parts of the book, but in the end of the book is 1705F. And 1705F does not allow them to do this. 17 and 28 certainly doesn't allow them to do this. Here's a compass rose, and here's an easy way to look at it. Here's a compass rose placed kind of in the middle where the south extension, the east-west connector, and the H.E. Bailey spur is. I'll acknowledge it doesn't say due east, but at some point easterly is not easterly anymore. And a compass shows us that. We don't have to guess and muddle in our heads. We can just get a good old-fashioned compass out. The OTA does it. There's little compasses in their things too. This is going due north. It's not going easterly to the vicinity of Norman. It's starting in Purcell and going northeasterly and then due north for most of its span. This is not a little 500-yard hookup or something like that. This is 19 miles of statutory violation. The old way they did it, it's 29 miles of statutory violation. Now, and again, credit where credit is due, and I don't want to steal thunder, but I thought, again, another party, the city made a great point that what 28 does is it kind of gives them a parallel route down here to 20. A parallel route. And we saw earlier in their studies that they kind of go across here to hook up, to go across the river and then hook back up with Highway 9. They decided not to do that. But it doesn't allow them to do this. And here, the ultimate trump card, the ultimate stop sign, the ultimate roadblock is 1705F, regardless of where they want to put that little loop that goes up to I-40. They don't have it under 28 and they don't have it under 1705F. There's another map. There's kind of a comparative little thing. This is the best we can do with what we've got to, again, show where they mess up. What they're supposed to be doing, you can see where the east-west connector would continue to go along Indian Hills. You can see where the spur is being studied. And then you go way down to what they're trying to do is start in Purcell and go up north again. So a few more things that I gleaned from what the OTA said. They said there's no question that these are authorized. I would submit that there's no question that they aren't authorized. It's very plain language of the statute. They tried to get authorization for what they're calling the South Extension in 1999. And again, that shows, what it shows is the OTA understands they don't have it. They tried to cross out Moore and Norman and put in Purcell in the House bill. In the Senate bill, they tried to say Moore or Norman or Purcell and effectively create the South Extension. They failed. They didn't get it. There's some people here who are in the room who confirmed that this southeast outer loop is dead. DavidStreb confirmed that it was dead back in 2000 after that failed effort to do it in 1999. It's no more alive today. What the OTA likes to do is go around saying, and they kind of said it here today, that these are a done deal. They're in statute. These are a done deal. They're in statute. There's nothing you can do about it. Well, they're not in statute. They're not a done deal. What they are, just as DavidStreb said back in 2000, they are a dead deal. They do not have authorization under Section 28 to do the South Extension. They do not have authorization under 1705F to chunk pieces of the outer loop by themselves without, now that they've done their one bond issue. And they're just trying to chunk the outer loop by itself without the other 4 turnpikes. What it really boils down to is plain language of the statute. History is shown by the evidence. They are not authorized to do any of these new turnpikes. And of course, our request is that the court ultimately reject validation of the bonds as to any of the 3 new turnpikes.
Thank you, Mr. Norman. The City of Norman.
May it please the court, I'm John Dorman. I'm with the Spencer Fain Law Firm in Oklahoma City. The City of Norman's position is very simple. The Turnpike Authority lacks the requisite legislative authority to construct and operate the proposed South Extension. The legislature reserved unto itself the power to determine whether a turnpike is to be built. And this reservation is found in 69 OS 1705E, which reads, quote, "Until specifically authorized by the legislature, authority shall be authorized to construct and operate toll turnpikes only at the following locations." 1705E then lists 35 locations where OTA has been authorized to construct the turnpike or construct turnpike-related items. Nowhere in 1705E does the legislature authorize the OTA to construct a 29-mile-long north-south turnpike on the east side of Norman that ends in Purcell. This court has long recognized that an agency created by statute may only exercise the powers granted by statute and cannot expand those powers by its own authority. But that's exactly what the Oklahoma Turnpike Authority is asking this court to do. OTA maintains that its authorization to construct and operate the South Extension is found at 1705E28, which provides, and I'll quote, and you've seen this several times already, but just for emphasis, a new turnpike and bridge or any parts thereof from a point in the vicinity of the city of Mustang, southerly across the South Canadian River to the H.E. Bailey Turnpike in the vicinity of the city of Tuttle, and then easterly across the South Canadian River to a point in the vicinity of the city of Norman. There is no mention of any other route. This subsection evidences the legislative intent that the turnpike is to end in Norman. As noted in the brief, the prepositional phrase used, "to a point in the vicinity of Norman," leaves little room for doubt. All of the words that might indicate a contrary intention, across, over, through, or even connecting, or loop, as found elsewhere in 1705, for example, the Creek Turnpike or the Kirkpatrick Turnpike. They're not there. This court has recognized in previous bond validation proceedings that the general rule is that all legislative enactments must be interpreted in accordance with their plain and ordinary meaning according to the import of the language used. The plain meaning of the words in subsection 28 do not support OTA's contention that it has the authority to construct and operate the proposed south extension that ends in Purcell. OTA's brief frequently references transportation plans and concepts it has been considering and developing for years. But unless and until the legislature adopts a statute expressly authorizing construction and operation of a project, these plans and concepts cannot serve as the basis for a funding authorization by this court. The OTA may have developed a plan or an idea or a concept that includes a new 29-mile north-south turnpike on the east side of Norman, but without express statutory authorization, a plan or concept is what the south extension project must remain, because the decision whether to build resides with the people and their elective representatives in the legislature, not the unelected Turnpike Authority. This is really a separation of powers issue. OTA is trying to avoid the legislature and, more importantly, the 128,000 citizens of the city of Norman and every other affected community by asking this court to validate $500 million worth of debt that it doesn't have the authority to issue. OTA shouldn't be allowed to short-circuit the process mandated by subsection 1705. Without legislative authorization to build the south extension, or whatever OTA wants to call the proposed 29-mile north-south turnpike across Norman that ends in Purcell, this court should reject its application to validate the bonds. That concludes my remarks.
Thank you, sir.
Thank you.
Elaine Dowling, on behalf of John and Joe Deaton McKay.
May it please the court, my name is Elaine Dowling, representing John and Joe McKay, and I was not aware that Mr. Norman was bringing projection equipment today, and so I brought printed copies of an enlarged version of the Exhibit 3 included in my appendix, if I may approach.
Yeah. Thank you.
This map is taken from OTA's website. It's a screenshot, and I have added some labels, which I think makes it a little easier to point out things. But when I first read about the new turnpikes in Access, Oklahoma, my first thought was, Purcell? Once I got into this, I realized that Purcell was simply an artifact from a plan for an expanded outer loop from the 90s. It might have been a great plan, it might have been a lousy plan, but the important thing is it was an unsuccessful plan. The legislature didn't approve it, and they had the opportunity. Bills were filed and introduced in the legislature specifically to authorize this route down to Purcell at I-35. Those bills did not pass. Copies of the legislation and the legislative history are included in my appendix. The legislature didn't approve this, the public hated it, and everybody moved on. Then 23 years later, here it comes again, Purcell. Of course, now it isn't being called part of the outer loop. It's being called the South Extension. And if you will look on the map, you can see in blue the South Extension snaking down beneath something in black that goes up to I-40. This clearly extends the Kickapoo Turnpike, which begins at I-40 and which begins at the Turner Turnpike and ends at I-40, This south extension clearly extends the Kickapoo Turnpike south down through Norman, Noble, Slaughterville, to end at I-35 at Purcell. And the Kickapoo Turnpike is, of course, part of the outer loop, which is where the whole idea of extending to Purcell originated, was with the outer loop in the 90s. Now, this same stretch of turnpike is being rationalized, if you can call it that, as phase 2 of the H.E. Bailey Norman Spur. And the authorizing statute would not be the outer loop statute, but instead 69 OS section 1705E28, which reads, a new turnpike and, well, it begins, a new turnpike and bridge, or any parts thereof, et cetera, et cetera, et cetera. If you look at this statute carefully, the one thing that it is specific about is this bridge across the South Canadian River. And phase 1, so-called by OTA, which we know as the H.E. Bailey Norman Spur, built that bridge and 8.2 miles of turnpike, connecting that bridge with Highway 9. Clearly, the bridge was the important part of E28. Now, OTA wants to shoehorn 19 miles of unauthorized Kickapoo extension into this statute, which is more than twice the length of the important part of the statute, the part they built. And this map makes clear, if you look at it, you can see the distance between the H.E. Bailey Norman Spur, which is in black and has H.E. Bailey Norman Spur printed underneath it, and the blue vertical drop of the south extension that's been pointed out many times today. But this map makes it clear that these are not two parts of the same turnpike. These are completely separate turnpikes. They're not even on the same side of I-35, and they do not connect. What I find interesting, though, I still find interesting, is Purcell. If OTA, to use their argument, and that this is the second phase of the H.E. Bailey Norman Spur, if they can skip all the way over Highway 9 and then skip down I-35 to Purcell, all while supposedly going easterly across the South Canadian River to a point in the vicinity of Norman, where else could they go? They could skip over Highway 9 all the way east to where Highway 9 intersects with US 69 near Eufaula, and then build a turnpike back to a point in Norman. Make getting to the lake a whole lot easier. But why stop there? Highway 9 goes all the way to the state line. We could have a turnpike from Arkansas to Norman. And all of those make every bit as much sense in the language of the statute as what they've proposed today. There's no question that OTA's discretion in the precise placement of turnpike routes, but they can't ignore their legislative authority, and shoehorning the south extension into E28 is doing exactly that. And their explanation for it, well, quite frankly, it's bunk. And we know it's bunk by the language that they use. All of the appendices filed in this case include lots of documents and publications produced by OTA. And every time they refer to the south extension, they refer to it, they never refer to it as a turnpike going up or north from Purcell. No, they always refer to it as a turnpike going south through Norman, through Noble, through Slaughterville, until it reunites with I-35 at Purcell. Language is power, and OTA's language is descriptive. Now, my brief goes into a lot more detail, statutory interpretation mainly, And I know this court reads those things, so I'm not going to rehash it. What I would really like to do is apply those same arguments to the other Norman area proposed turnpike, the east-west extension. The statute I would like to focus on, again, is, not surprise, 69 OS, section 1705F, which provides that any bonds issued for the construction of the proposed turnpike referred to in subparagraphs 10, 20, 21, and 22 of paragraph E of this section shall be issued as one issue for all four of the proposed turnpikes and shall be financed, constructed, and operated under one bond indenture. Now, I was a literature major, so I had to look up the phrase bond indenture. And according to Investopedia, a bond indenture is a legal and binding contract usually associated with bond agreements, real estate, or bankruptcy. An indenture provides detailed information on terms, clauses, and covenants. Now, OTA's problem here is that they started building the outer loop in 1991 with the Kilpatrick. And the most recent phase of the outer loop was the Kickapoo, which opened just a couple of years ago. And they have asked this court to approve bonds for outer loop projects more than once. And I don't think those all qualify as one issue or one bond indenture, which is made obvious by this court's opinion in the matter of application of the Oklahoma Turnpike Authority, 2016 OK 124, decided December 13th, 2016, where this court discusses some of the history of the outer loop and its financing. And it's a shame that no party has raised 1705F in any of those proceedings, or we might not be here today. Now, I'm a statute should say what they mean and mean what they say kind of lawyer, and I think this one does. But other than just the plain language, we have a few other rules of statutory construction which support the position that OTA cannot finance the outer loop with a proposed bond issue. Since at least 1916, this court has valued the construction of statutes given to them by, quote, officers in the discharge of their duties, close quotes, which had been long acquiesced in. Hunter versus State ex rel City of Shawnee, 1916, Oklahoma 34, 154P, Pacific Original, 545. As pointed out in the newspaper articles included in Mr. Norman's appendix, Governor Bellman, certainly an officer in the discharge of his duties, believed that Section 1705F prevented building the profitable parts of the outer loop first and the rest later. OTA's then director, Neil McCaleb, seems to have agreed. I would suggest that they should know, and that this court has traditionally been willing to give those opinions expressed at the time some credence. In short, neither this bond issue nor these turnpikes seem to have been well thought through. I'm one of the lawyers who filed one of the pending state court cases, and in those cases we have received, at least so far, no answers to questions about how the routes will be modified to move around property in at least two stretches of the south extension that are protected by federal easement or other federal interest.